right, counsel, let's proceed.
Good morning. May it please the Court, I'm Mary Ann Chase. I'm here on behalf of the defendant, PM. This is a case where the trial judge issued very strong findings in favor of the defendant. However, he stopped short of ordering expungement of the criminal record which was requested, even though he said that expungement was merited in this case. But he stopped short of ordering that expungement because he did not believe that he had the inherent authority to do so. So we are asking this Court to clarify that in the event of fraud on the Court, that the Court has the inherent authority to expunge regardless of the type of record and regardless of statutory authority.
So if you claim that the difference between this case and Bowe is that was a mistake and this is fraud?
Yes, Bowe was.
But both of them, neither of them involves inaccurate court records. I mean, I don't think there's any question but that the person who was accused here was PM. I mean, right? I mean, I'm comparing it to the SMF case, but.
Right. That's correct. Well, this Court actually clarified in Bowe, clarified the SMF case. SMF is the only criminal record that's been expunged in over 30 years, other than Balboni, which was a procedural issue. But SMF is the only case that was expunged, and that was because of fraud. And this Court clarified that it was because of fraud in its Bowe decision. Bowe was a case of mistaken identity, as was arguably SMF, and it was widely thought to be a case of mistaken identity as well.
I'm talking about, and I guess this is your point, it shouldn't make any difference, but I'm wondering, isn't it different where the fraud is, in SMF, the court records are incorrect because SMF, himself, wasn't actually the person charged. In other words, the real defendant had a different name, correct?
Correct.
So the court records were not correct.
It was mistaken identity. There was a Hispanic male versus a non-Hispanic female.
Well, that's Bowe.
No, that's
Oh,
Bowe.
that was Bowe, yeah.
Yeah, but in SMF, the court records were incorrect. So that the court records, as a result of the fraud, were incorrect. Here, the court, I mean, one may say as a policy matter, what difference is it? But the fact is, right here, the court records are correct. The problem is before they ever got to court, you say Mr. Benzon committed a fraud.
I believe that a case of mistaken identity is certainly a factor, and it's
Well, it was
one
a
of
lot worse than mistaken identity in SMF. The person went into court and testified in front of a judge that he was somebody who he wasn't.
Yes.
And the person who he wasn't was the one that ended up bearing the brunt of that lie. That really was a lie to the court as to who was the litigant.
Yes, it was.
And here you have just false testimony.
Well, in SMF, there was the lie to the court, and that constituted the fraud on the court. And this court made that clear in Bowe. Although mistaken identity or mistake was a factor in that case, it was the fraud that caused the allowance of the expungement.
Yeah, but every time false testimony alone is not enough. Do you agree?
Yes.
For a fraud to cause a fraud upon the court, you need something more than just false testimony.
Well, we have the case of Thoreau, where there was one false statement made in an affidavit in an application for a restraining order, and that was sufficient for the appeals court to allow the expungement. So,
But that was expungement of not of a court record, but of the restraining court documents, which was not part of 100C.
I'm sorry?
The court said there's no statute which governs it. That in the case that you're mentioning, it was not a court record within the meaning of Section 100C, the case that you're referring to, with regard to the restraining order record.
That's right. It came under 209A.
Okay, so here there actually is a statute which we have interpreted to say does not provide for expungement except in a very, very narrow set of, well, I guess the question is how narrow is that set of exceptions? You basically are saying the exception should be a fraud upon the court.
Yes, and I'm saying that on the basis of SMF because fraud was found in SMF, which caused the case to fall within the residual clause of the sealing statute.
Okay, but the difference, of course, as has been mentioned, is that the nature of the fraud in SMF is that the record itself would be wrong. The record saying that the SMF was before the court was, in fact, not true. And so you can't rely upon that narrow piece of fraud upon the court. You need a broader definition of fraud upon the court.
Well, that's also true in this case. The record in this case is false, too, in that the false statement said that PM was involved in a violent incident involving the use of a gun, when, in fact, the incident never occurred and he's never owned a gun.
But wouldn't your exception then devour the rule? I mean, what's left of the rule if a false allegation, this matters only when there's a null pros. The very essence of a null pros would be the information is either false or unprovable. So it seems as if your exception will devour the rule.
I believe the implication of a null pros is, as you said, that it's either false or unprovable, and that's just why expungement is the only remedy, because that leaves a cloud of prosecution over the defendant for the rest of his life. Just as in Adams, the court found that saying the restraining order was vacated or dismissed would be insufficient. It would be insufficient that only expungement was the only remedy in that case, because anything short of expungement would not cure the defiling of the court and would not cure the harm to the defendant. And I believe that's the same case here in having a null pros for the rest of your life. The sealing statute has cases that are sealed do have very wide distribution. And as an attorney, the judge found that he has already been and will be seriously harmed by the record, which is why he felt that expungement was merited, but that sealing may be the exclusive remedy. I believe that the records which have been sealed are entered into the carry system by the Commissioner of Probation, but those records are merged with CORI on a daily basis, which is administered by the Criminal History Systems Board. And the police commissioner of Boston case in 1978 said that 216 agencies had access to those records as of 1978.
But now you're speaking of police records or CORI records as opposed to the probation records that are at issue here, correct?
Well, for example, adoption agencies have access to sealed records.
With regard, I know that your request also was with regard to police records. Was notice given to the police commissioner or to the Criminal History Board that you were seeking to expunge their records as well?
Yes.
You gave notice to the police commissioner?
The motion to expunge included service to all of those parties. Only the Commissioner of Probation responded.
And where is that in the record? Because what I had read is that I thought PM said he gave notice to the DA and to the probation office, but I didn't see anything in the record which suggests that that notice had been given to the police commissioner or to the
I believe the motion to expunge includes all of that.
Well, I know that that's the relief sought. I'm asking about notice given because the juvenile case says if you're going to do that, you have to give notice to all the parties whose records you seek to expunge.
I will check that and inform the court in writing if you
So not juvenile, it's police commissioner of Boston case that expressly says you can do it, you can seek to expunge in the criminal proceeding, but you have to give notice to all of the entities whose records you seek to
I
expunge.
wasn't involved at that level, but I will check that and inform the court. Okay. Well, we feel that the findings of the lower court judge were very strong findings in favor of the defendant. They were uncontested by COP, and the judge's decision says that. What we have a problem with is we think that the judge misapplied the cases that he relied upon in reaching his conclusion, and that is SMF and Bowe, which we just discussed, Gavin G., where he seemed to rely on his belief that Gavin G. was a case where somebody lied about Gavin G.'s involvement in the affray, and just as they lied about PM's involvement in this violent incident with a gun. However, that wasn't the case at all. Gavin G. never said anyone lied. He never said there was any fraud involved in his case. Gavin G. was appropriate for the sealing statute because the record was accurate and there was no fraud involved. But the judge thought that the reason Gavin G. was denied was because somebody lied about the incident, as they did in PM's case, and that wasn't true at all.
Isn't it possible that if one says that, in this case, that the fraud, which didn't happen directly in the court, I mean, it happened before, obviously, if one says that's enough for expunging, and I take it would have to be through the inherent power of the court, not through the statute, obviously, because the statute doesn't.
I'm sorry, I can't hear you.
I'm sorry. If one said that expungement was, the judge erred in not expunging in this case, it would have to be because through the inherent power of the court, not through the statute.
Yes,
right?
correct.
So if one went that way, if we went that way, doesn't that open up the possibility that in many cases where that there will be claims that the accusations that gave rise to a complaint were fraudulently made? In other words, does it open up a host of cases where this, I mean, the argument may not be successful, but where there will be an argument, you should expunge my record because X lied when he spoke to the police that I did something. Yes. And then you have to go through a whole proceeding about whether X did or didn't lie.
I understand that concern. That was the concern in the Amanda Adams case as well. And I think that case was 6 years ago. Since that time, there have only been a handful of appeals on that very issue, and only one has been successful. So we did not enter into a slippery slope because of Amanda Adams, which is essentially the same thing. If you can prove fraud, then your record may be expunged. I would also submit that the Adams court did say that where there is fraud, the statutory authorization is not needed, and expungement would be the only remedy to cure the defiling of the court and the harm to the defendant. In this case, the trial judge essentially did find fraud, just as they did in the Adams case, and he found grave injustice and he found harm. In fact, he found all of the elements warranting expungement, and the fact that he failed to invoke his inherent authority, we believe, was an error of law. We believe that the court's power to preserve its own integrity cannot be restricted or abolished by the legislature, and that use of its inherent authority in cases which are inappropriate for sealing, as we believe this case is, does not offend separation of powers, which is an issue that has been raised in the case under Article 30 of the Massachusetts Declaration of Rights. Before a court can actually exercise its inherent authority, it must conduct a balance of the harms test. And in this case, there is no utility to the courts or to law enforcement in maintaining such a misleading record. In fact, the record is entirely false for the reason I said, that he was never even involved in the incident, and he certainly never owned a gun.
No, your time is up, so you're going to have to wrap up now.
Oh, I'm sorry.
Yes, ma'am.
Fine. Then I would just maybe point out some of the social implications of allowing expungement in this case, and that is, if it is clear that where there is fraud, the court may invoke its inherent authority regardless of the type of record and regardless of statutory authority, then that will provide a remedy at the district court level for persons who have been harmed by fraud but who may not have the resources to seek appellate review. I don't believe that creates the slippery slope, because that did not prove to be true in Adams. And I would also think that this would be an opportunity to reinforce the message in Rockdale management that the courts will not be used to abuse or undermine the judicial process when a party deceives the very institutions which have been set up to protect it. And finally, it will bring to criminal records the clarity that Amanda Adams brought to expungement of restraining orders. Thank you very much.
Good morning, Your Honors. My name is R.G. Cosmetato Shapiro for the Attorney General's Office on behalf of the Commissioner of Probation. May it please the Court.
Can refresh my recollection?
Yes, Your Honor.
All right. So you have a case, criminal case that's brought on the basis of a false statement to the police. Just use this as a hypothetical. And the statement is made as part of an effort to extort money from the accused. It doesn't work. He doesn't pay the money, but the complaint has already been made, and this is recognized by the district attorney, who processes the complaint.
Yes.
And you say sealing is an adequate remedy. Who gets access to sealed records and how?
The statute was recently amended, Your Honors, and under the old and new amendments to the statute, the public does not get access to sealed records. Under the old version of the statute and the new, law enforcement gets access to a printout saying that there's, as I understand it, that there is a charge. I don't know if the printout says it was not processed, but that the record was sealed.
Okay.
And now adoption agencies can get access to it. But the important part...
Get access to what?
To a printout saying, but I believe that they have to go to court to petition to get a look at the sealed files.
So an adoption agency, which is relevant here, would get a record saying, aha, you have a sealed record.
I believe that they would. However, importantly here, Your Honor, where a case is now processed under, as I understand it under the new amendments to the statute, if a case is now processed, it will no longer appear on any, it will no longer appear.
The adoption agency won't see it? Is that what you're saying?
I'm not clear about that. I think the adoption agency will, may I have a moment, Your Honor?
Sure.
If a case is now processed as of May 7th, it will not show up on probation printout. So if an adoption agency wants a record from the Department of Probation, it won't show up on the printout, as I understand it.
Can they get it from any other source?
Yes.
So that they can get a printout somewhere that shows that this person had a criminal complaint brought against him and it was no processed.
Not even
No,
that.
just
Just
no.
that it was sealed. The
It
record was
will
sealed.
That
say
it was
sealed.
sealed. Yes. I can't speak to police records, but I can speak to the court activity records and the probation department records.
So if they were authorized, I don't know how this works, but there's a variety of agencies, right, or parties that can seek records from the Criminal History Systems Board, right?
Yes.
So those records would show this person has a sealed record, wouldn't they? Or would
I believe they would. In this case, Your Honors, the legislature, as this court has said in a long line of cases from Vicky to Balboni to Rowe to Gavin G. and most recently to Bowe, the legislature considered the confidentiality interests of people who are arrested, whether wrongfully or by mistake, and said that the legislature made an express directive in the statute that for cases that are now processed, as was the case here, sealing is the appropriate remedy. And that holding was clear in this case. There was no fraud on the court in this case, and this case is nothing like SMF. There was a deliberate act of prosecution, as Justice Botsford pointed out, against PM. The record was accurate. There was no imposter here. And more importantly, also, there was no null pros in SMF. The case proceeded. The prosecution didn't drop the case. It had every intention of pursuing the case against the actual perpetrator of the crime. So in SMF, the appeals court also made the point that this did not fall into either of the two provisions of the sealing statute. And so therefore, the court had the inherent authority to expunge SMF's records. This case does not present those circumstances here. And as this court has defined fraud on the court in Rockdale Management, there has to be perjury, an egregious lie, and to the court, and the court has to have relied upon that lie, that perjury, to have issued a judgment against the defendant. This didn't happen here. In all of those line of cases, like Adams and SMF, what you had was the liar pretty much representing in an affidavit falsely that something happened that didn't happen, under oath, and he came to court, he testified at hearings. You didn't have that happen here, and as Justice Botsford pointed out, the allegations here occurred before the case ever got to court. There was a system in place in criminal proceedings. The clerk magistrate had to find probable cause. The defendant was arrested for the crime. The arresting officer came to court, applied for a complaint, got the complaint. The clerk magistrate found probable cause, and ultimately the case was now processed. The system worked. And the rule that PM is proposing here is simply untenable, because if this court adopts that rule, where will the line be drawn? Are you going to limit the rule to complainants who come to court? Are you going to limit the rule to complainants who accuse somebody of committing a crime? And then are you going to expand the rule to other witnesses? Are you going to expand the rule to defendants who are found not guilty after a finding of not guilty, and then who can come back and say, I want a hearing on why my case was not processed? It's simply untenable. It will open the floodgates to more litigation.
Well, we do have a provision regarding actual innocence, so that at least partially addresses the not guilty by reason of actual innocence. There's a provision that does actually also have a component in addition to damages expungement. So we're not asked to here deal with a mere witness. We're asked here to deal with a circumstance where it looks as though there was an individual seeking to use the criminal process, all of it, he only got started before he presumably was maybe deported, by lying, which put into action and could have gone further. So you're saying, well, it happened not to, so it's okay, notwithstanding the fact that there's still this sealed record. It's a narrow circumstance. It's using the process, the criminal process, for personal gain, and using that process by lying to help in an extortion scheme.
There was no finding. First of all, the court below did not find that there was a fraud on the court. per se. It found that apparently he made false accusations. And in Gavin G. and in Bowe, this court said this stuff happens all the time. This is why cases are not pressed.
Would it have made a difference, though, to your analysis if those things had been found?
If those things had been found,
Instead of apparently there was a lie, there had been a fraud. Let me ask it this way. Is your concern that, as you argued, that it wasn't a lie to a judge or in an affidavit? Is that the sole
that's part
concern?
of it, Your Honors. Had he made the assertion in an affidavit and had he come to court, it may have been a different story. Here, he didn't do that. He alleged to a police officer, and the police officer came to court and applied for a complaint. He wasn't lying to the clerk magistrate.
I was asking the question because you then also said, well, it's not established that there was, in fact, a fraud in the sense that there was a lie and an attempt to extort. If those things were established, would it make a difference in another case, hypothetically?
In this case,
hypothetically, would it make a
hypothetically
difference to your
speaking,
analysis?
if the judge had found that there was a fraud on the court, he would have been respectfully in error, because here there was no fraud on the court.
If I understand correctly, you're willing to stipulate that there was a fraud committed by Mr. Benzan. It's just that it wasn't on the court. I mean, the fraud in the sense of lying to the police officer. And
At most.
okay.
If that's the case, but the judge didn't even find that here, Your Honor.
But your argument doesn't really depend on, I mean, your
But we
argument
never-
seems to me to say, even if that were true, it wouldn't make a difference because it was not a fraud on the court.
Yes. However, I also would like to point out that we never conceded that there was fraud on the court below. So that's not even
No,
our
I'm talking
position.
about any court. I don't mean.
Yeah. I mean, it wouldn't matter here because he didn't commit a fraud on the court in this circumstance. And in all the other cases, if you look at Gavin G., SMF, Vaccaro, there were representations made to court. The person came into court, swore under oath in an affidavit, looked at the judge, testified. We didn't have that here. He didn't even get to court. The system worked.
If it worked perhaps a little better and there'd been a magistrate, would that count?
Are you and is your question whether a magistrate is an extension of the court? I think that your definition in Rockdale management of fraud on the court is perjury, but the court had to have relied upon the perjury in issuing a judgment. Here, the clerk magistrate was issuing process. There was no judgment. Your Honors.
I understand your analysis.
Thank you. Your Honors, the legislature made it clear here that sealing is the appropriate remedy for preserving the confidentiality of records in a person such as PM's position. And while this court recognized that Ms. Bowie's situation was unfortunate, and perhaps Mr. PM's situation is unfortunate, because the legislature has spoken, inherent authority cannot be invoked here. There was no fraud on the court for the reasons we lay out in our brief. There was no specific harm alleged. And before we can even find that even under PM's weighing analysis here, he has not even met that threshold of showing specific harm. And we would ask that the court affirm the lower court's expungement, sealing order in this case. Expungement is not merited. Thank you.
All right, thank you. We'll take a brief recess.